Good morning, all. Good morning to everybody.
Recording in progress.
Good morning. Can we start? We have a busy day today. We will start with the listing and conditions of service for the Information Regulator, followed by South African Human Rights Commission. And then thereafter, we'll deal with the issue of Judge Motata. And then we will also deal with the update on the study tour and correspondence from the Minister of Transport. And then we will deal with the minutes. I proposed that we end this meeting by 1 so that people can prepare to go to the house. Will that be fine?
Yes, Chair.
Thank you very much.
Yes, Chairperson.
Thank you very much. The agenda is taken as read. Any mover for the adoption of the agenda as it is?
Chair Swatcher moves to accept, and just again, I'll be in and out of the meeting. Please accept my apologies. Thank you, Chair.
Thank you very much. Any seconder?
Honorable Neo Jochen, seconds, Chair.
Honorable Neo Jochen, seconds. Any objections? Honorable.
I have no objection to the standing apology. I have no objection.
We note that that Honorable Janji. It will be part of the next. It will be part of the next agenda next week Sunday. Can we start with Popia, the information regulator? Are there any apologies?
From our side, there's that one from Honorable Yako.
Yes.
And the second one would be the Minister of Justice. Is currently out of the country.
Yeah. Members, I think we should really pray for Honorable Yako. She is not well. We should pray for her speedy recovery. Thank you very much. Can I now invite the Minister of Finance? We received, the Deputy Minister of Finance, in fact, we have had engagements with the Information Regulator on a number of occasions, and they consistently raised the issue of their listing and the fact that they are dependent on the Department of Justice for their procurement, and that compromises their independence and it creates conflict of interest. And the fact that there has never been a determination of their conditions of service. They do not know how many leave periods they have in a year. That has not been determined. What they were only told is that the chairperson will be remunerated at the level of a director general. And we have also had some of the regulators initiating proceedings against the regulator because they were not paid. And sometimes the scale would change. And so they asked that the committee intervenes because they have raised this matter with the department, the Department of Justice, they have raised this matter with the Department of Finance to a point where they have written several letters to the Department of Finance that were not answered. There was a meeting that was held around 2018, but subsequent to that, they claimed that some of the letters that they've written to the Minister of Finance and even to the Acting Director General of Finance were not answered. So we thought that we should call this meeting where both Finance, Justice would be present to establish as to what is the issue and how can we be of help. We are particularly concerned because the Information Regulator is accounting directly to the National Assembly. So it is the National Assembly that has got an obligation to protect that regulator. It is independent and accountable to the Constitution and to the law. That independence must be seen in action. So we just want to intervene as the committee to check what can be done to ensure that this impasse is dealt with. So can I take this opportunity firstly to invite the Minister of Finance or Deputy Minister of Finance to brief us?
Thanks, Chair, and good morning to the Portfolio Committee members of Justice and Correctional Services and DM of Justice, because I understand that the Minister of Justice is not present. My colleagues as well from National Treasury and everyone on this public platform. Chair, Ministry and the department, we really appreciate and understand the importance of the information regulator and other such institutions in our democracy tasked with promoting and protecting the rights of South African. It is our understanding that the information regulator was established under the Protection of Personal Information Act and the promotion of access to information PAIA, as we usually call it, that the regulator is the primary role of promoting and enforcing protection of personal information and access to information in South Africa. And without doubt, to properly perform this function, the information regulator must be provided with the requisite capacity. And in this regard, the entity will understand that it has had challenges with finalizing appropriate institutional structure and remuneration set up to allow it to get on with its duties. And we do acknowledge the difficulties that the regulator has faced in this regard. And to the matter at hand today, that is the determination of benefits and conditions for members of the information regulator in South Africa. It is just worth making a few points about the obstacles preventing us in concluding these issues and what we think should be the way forward is. Firstly, the regulator consists of a chair and 4 ordinary members, 2 of whom are appointed in a full-time capacity. These members were appointed in December 2016 by the President and in line with the POPIA. And the regulator needed to consult the Minister of Finance on the establishment of its administration and the pay structure of its employees. And these consultations are ongoing and admittedly have taken much longer than they should have. And in this regard, the chairperson of the regulator, Advocate Pensitla Kula, has asked inter alia that the PFMA should be amended by including the information regulator under Schedule 1 of the PFMA. And after due consideration, it was the view of the Minister of Finance that is not vested with such powers in terms of the PFMA to amend Schedule 1 of the PFMA. It was also of the view that the Minister, together with his colleagues, particularly the Minister of Justice and Correctional Services, that the review of all institutions that fall under the justice portfolio, including the information regulator, was necessary before a final determination of conditions of service appropriate to the information regulator could be determined. This process will allow a proper understanding of the related financial implications, and this cannot be determined before this review is undertaken. This review falls under the obligation of the Department of Justice, which of course, it has to be done with the support of National Treasury. The fact is, Chair and honorable members, the remuneration practices in government entities have become misaligned because of a fragmented system, and that there are significant differences between the remuneration of senior managers in public services and those in municipalities, public entities, and SOEs. And this is why we agree with the suggestion by the Justice Minister that this review must be performed. For now, in terms of the way forward, the Chief Directorate within National Treasury is tasked with assessing the matter and is in regular contact with the Department of Justice as well as the information regulator, with the aim of developing a roadmap on how best to do this in a timely manner that does not continue to place pressure on the regulator's operation. So in summary, Chair, it is our view that there are 3, if not 4 issues here. One, it's the issue on whether the information regulator should be a Chapter 9 institution. And our view is that this does not fall within us as the Ministry of Finance. The second issue is that the remuneration stroke the conditions of service of the regulation of the information regulator need to be preceded by a review, some benchmarking exercise, which we understand it is being done by the Department of Justice with the support of National Treasury. The third one is that the Department of Justice wrote to the ministry and seeking concurrence insofar as the existing conditions of service, which does not necessarily include, as an immediate request, the issue around the remuneration of the colleagues working in the information regulator, because that is already catered for. They are being paid on the basis of the rates that are there. And that is being reviewed from our understanding, the remuneration part. But there's other aspects of the conditions of service, which includes leave, official traveling and all that. And that, we must admit, Chair, that it is taking long, and it's something, in my view, we should have quickly dealt with as the ministry. And we want to commit to the committee that insofar as these other aspects of the conditions of service are concerned, which require the concurrence of the finance minister, we will make sure that we expedite the process of the concurrence, because it cannot be right that the information regulator is in limbo on some of the conditions of service, taking leave, traveling and all that. We're making it very difficult for the information regulator to basically operate. And we undertake as the finance ministry to expedite this process while sorting other broader issues which may take longer. But on these ones, on the other aspect of the conditions of services, we should deal with these issues very quickly. I mean, I don't think that without having consulted the minister, I don't think it will take even more than a month to just finalize this and come back to the committee on those aspects that need the immediate concurrence of the minister. Thank you, Chair.
Thank you very much, Deputy Minister, for the briefing. But I must say, just before I allow members, it is deeply concerning that this matter has been going on since 2016, because it simply means that we passed a law, both as the executive and parliament, without knowing that people who will be implementing that law, what benefits will they have? And that is poor planning, and that is recklessness. And the fact that even, I think, I'm just pleased that you are indicating that within a month, you are prepared to come back with something that is tangible, because they are going to be finishing a second term without basic things having been done. And we can't say we are committed to their independence as an institution, which is very critical, which also that independence must be protected, because it's also about their credibility. That even if they want to do things, they have to to be seen as a sub-program of the Department of Justice. That was not the intention of the legislature. But I would allow members to express their views or ask questions on the presentation made by the Deputy Minister. Honorable Horn.
Yes, thank you, Chair, and good morning from my side. I agree with you, Chair, that, I mean, it can't be speaking to full functionality or effectiveness. This is a institution and legislation of the past few years, and if we are nonetheless faced by debilitating inefficiencies caused by it, then it is a big worry. And therefore, as you say, the undertaking that we will get hopefully a final a report within a month is to be welcomed. Having said that, Chair, the one aspect which to my understanding has been at the heart of this, which I am not forming an opinion that would be part of what we will be receiving a final presentation on within a month's time, is of course the issue of the listing. So I don't know whether the Deputy Minister is in a position to brief us about that, but to my understanding over the years, that has been at the heart of the issues. Of course, remuneration is important, but for the full functionality of the Information Regulator, the listing has been at the core of the matter, and it is a concern that the presentation has not dealt with that. Thank you.
Thank you very much, Honorable Horn. Honorable Nieuwoud Trochen.
Thank you very much, Chairperson, and good morning to everyone on the platform. Thank you to the Honourable Deputy Minister for the presentation. I can't overemphasize what the Chair and Honourable Horn has just said. I think it's very disappointing that the head of the Information Regulator had to come before us and ask for our assistance with regard to the issues that they have. I mean, they deal with critical things, the protection, especially of the country. When we see a lot of cyber attacks, etc., their work is critical, and I still don't understand why has it taken so long. I still don't understand what was so complicated. Why can this issue not be resolved? Because of the conditions, especially with regard to the conditions of service. And I don't know, whether the Deputy Minister or in the presentation can explain to us why and what has been so difficult to resolve this issue. That's it. It's from me. Thank you, Chair.
Thank you very much, Honorable Breitenbach.
Thank you, Chair. Yes, I fully agree with the comments made by yourself and my colleagues. It's exceptionally concerning that from 2016 to now, the Information Regulator has done nothing but struggle and goes sort of under the massive burden of perennial and chronic underfunding. It is an important office. It has to take care of so many important issues, not only access to information, but also cybersecurity and others very serious issues. And they just don't have the money to do it. And everybody pays lip service to it. Everyone tells us how important they are. Excuse me, my manners are poor. Thank you to the Minister of Finance for attending the meeting and for the briefing. I see that our own Minister couldn't find the time in his diary. Somewhat disappointing. The Information Regulator is such an important office. It should play such a massive role. And it's one of those offices that must be funded. And the kind of work it does doesn't come cheap. So it's no good giving it the budget of a smarty box if you wanted to do a Rolls-Royce job. It's just not going to be possible, and we all know it. And there's been no will whatsoever demonstrated to properly resource the information regulator. And I find that extremely disappointing, and it just shows that there is no seriousness in tackling the issues that the information regulator is responsible for. And they can do their very best and work 24 hours a day, but with what they've got, they can't do the job they're supposed to do. So I sincerely hope that we will be able to make some difference in that office in the very, very near future. I would also like to hear about the listing. It's deeply concerning that this matter has still not been finalized or even addressed. Thank you.
Thank you very much, Deputy Minister John Jeffrey. I think let's first allow the DM to respond, then we'll have your own time to make a presentation on the role played by the Department of Justice.
No, thanks once more, Chair, and I really want to appreciate the comments made by honorable members, and I do accept the criticism that this matter has taken long, and I take full responsibility on behalf of the department for delaying this matter, and I commit on behalf of the department that within a month we will come back with much more tangible progress on this matter, so that we don't, as members correctly pointed out, criticize us, that on one hand we acknowledge the importance of the information regulator, but we slow in resolving or trying to resolve some of the challenges that the institution is facing. On the listing, I've been advised that, and it's the minister's understanding, that the minister does not have the authority to establish constitutional institutions, and he has no powers vested in him in terms of the PFMA to amend Schedule 1 of the PFMA. However, the Minister of Finance may, in terms of Section 47, subsection 1A and B of the PFMA, by notice in the National Government Gazette, amend Schedule 3 to include in the list of all public entities that are not listed, and make technical changes to the list. So I do think that the issue around the listing, we need to have guidance here on whether the listing is in relation to making the information regulator Chapter 9 institution. And if that is the case, then that would require a different process altogether, which, of course, the Minister of Finance will participate, but does not have the authority to basically deal with the listing in the context of making the information regulator a Chapter 9 institution. And I must admit, Chair, that, and like I said, I will take full responsibility for this matter. I've not been dealing with this matter directly on a regular basis as a Deputy Finance Minister. But I do undertake that. So if I ask certain questions that seem to be off the mark, please forgive me. It's out of the fact that it's only now that I'm dealing with this matter in the context where I've been asked to appear before yourself to deal with this matter. But so if I ask certain questions that are off the mark, please forgive me. And if the ask is not to make this information regulator Chapter 9 institution, it just comes out of a recent briefing that I basically had. So if I'm asking questions that are off the mark, please understand it in that context. But we will come back within a month and to deal with those important aspects of which are within the ambit of the ministry, that the conditions of service, because they do for the information regulator to work on the basis of the certain conditions of service, that office requires the concurrence of the finance minister. And unfortunately, like I said, we've taken too long, and we commit that within a month we will deal with this matter. We'll come back to the committee with a concrete answer to seek to finalize this matter. Thank you, Chairperson.
Thank you very much, Deputy Minister, and thank you for the commitment that you have made. I think it will form part of our way forward. Thank you very much, Deputy Minister. Honorable Masego Jele, is it on what the Deputy Minister has raised?
Yes, Chair, it's just a small thing. Good morning, Chair and the team and Deputy Ministers. It's only one thing, Chair, I wanted to find out from the Minister is, I hear him by his admission that there has been a delay, but was he aware that there is something like this, that now he is able to sort it? Because the one that he says will take care of it also in a month's time. I wanted to find out, was he aware about what is happening with the regulator, and for how long? Thank you, Chair.
Thank you. If I understood him, he will correct me if I'm wrong, is that he is not necessarily dealing with these matters on a day-to-day basis. And he became aware because he was delegated to deal with this matter today. I think we should hold him accountable on the basis of the commitment he has made today. But if I'm misquoting you, DM, you will indicate.
You're correct, Chair, if I may come in. The correspondence was largely between the two ministers. And the matter was brought to my attention by the DM as we're preparing for this meeting. And that's why I got a full briefing on the matter. And I think we do have division of labor within the ministry, but this matter was not within one of the areas that I was dealing with. So the Chair is right. Now that the matter has been assigned to me, I will come back on behalf of the ministry within a month on those aspects that are within the ministry. Thank you, Chair.
Very much. Honorable Chair, is that an old hand or a new hand?
No, I meant to say it's the old hand, Chair. And thank you for the response from the Minister. Thank you.
Thank you very much. Let's now invite Deputy Minister John Jeffrey.
Meeting of the Regional Court Presidents, so hence I'm a bit informally dressed. But just to thank the Portfolio Committee for the putting this item on the agenda, because it has been going for some time, and to thank the Deputy Minister of Finance for his attendance and his commitment to resolving the issues. But maybe just to give other background. On the issue of listing, the problem is that the Protection of Personal Information Act, which creates the regulator, states that the accounting officer of the regulator should be the CEO, not the regulator. In terms of the PFMA, that can only happen to government departments and constitutional institutions. So we've got a conflict in our law between the PFMA and the Protection of Personal Information Act. And that's what needs to be resolved. And the issue is not making the regulator a Chapter 9. The issue is, can the regulator be listed in Schedule 1, which is constitutional institutions, because the regulator is not a department. And there was a reason why Parliament wanted the executive officer to be the accounting officer. It is, although it's not mentioned in the Constitution, because under that section, it's not just the Chapter 9s, but other bodies such as ANSAL and the Demarcation Board and so on. But it is set up to ensure the implementation of the rights of access to information and the rights of privacy. So that's the issue with the listing, and with due respect to the officials from Treasury, and let me just say, because I was involved in the processing of the bill in Parliament, I was still a member of the Portfolio Committee, and Treasury were very involved in the bill because of the implications for financial information. They didn't pick it up then, but that's the issue. It's a question of, the Act says the accounting officer is the CEO, but in terms of the PFMA, that can only apply to government departments and constitutional institutions. We know the Minister of Finance can't, by proclamation, amend the PFMA, but it's a finance act. Ministry of Finance would have to amend that act. That's the issue, the listing. Then the issue of the benefits, conditions of employment. I think, as we've reported before, the Minister of Finance, well, the first issue was what should they be? So we actually approached the regulator to say, but what are your proposals? They then sent them to us, but together with that, they also sent a request for their status to be upgraded, for them to be paid at a higher level, to be benchmarked with the Elections Commission, the International Independent Electoral Commission. The Minister of Justice's response to that, or he forwarded that to their letter to the Minister of Finance, was to say, look, that issue requires more discussion and more research. And that is what the benchmarking. However, then he had requested that the conditions of service and benefits that he needs in terms of the Act, the concurrence of the Minister of Finance, and he had requested that concurrence, and it's good that the Deputy Minister of Finance has undertaken that will be responded to within a month. So I just wanted to give that, Chair, by way of background, but hopefully the Treasury officials can look at the question of Parliament wanted the regulator to have their executive, their CEO as the accounting officer, and said that in the Act. That doesn't correspond to the PFMA. What can be done about that? Can the PFMA be amended to ensure that the regulator can fit under the same section as departments and constitutional institutions? Because Parliament did not want the members of the regulator to be the accounting officers. So, Chair, I just wanted to give that by way of background. I don't know if there's anything else you want me to respond to. The ball is in Treasury's court.
I suspect that we might, in a month's time, we might be back to where we are, because when I read the documentation, seemingly around 2018, a similar meeting set, and there was no agreement. I would have thought that by this time, there would be proposals for what would be the immediate relief and what would be the long-term solution to this particular problem. Because, of course, I think National Treasury, in amending the PFMA, they would look at the broader impact of that amendment also to other institutions. So I would have thought that by this time, because we have always known what the problem is, that we would be much wiser as to how we solve the problem. I don't think that we are any wiser. We are just diagnosing what the problem is, and I'm not convinced that there is a solution. Because the
Chair, I
solution
think that's on the listing issue.
is on the list.
And the issue is, and it would be for Parliament, the Protection of Personal Information Act specifies that the CEO is the accounting officer. The problem is that there's no provision in the PFMA for that. It's only for government departments and constitutional institutions that you have the minister as the executive authority and or in the case of the constitutional institutions, the boards, the committees as the political, the executive authority, and the CEOs as the accounting officer. Now, I think the issue is basically, and it's also to the committee, was Parliament wrong when it passed the Public Finance Management, when it passed the Protection of Personal Information Act, to say that the executive authority, the CEO, is the accounting officer? So I'm throwing it back also to the committee. Was that wrong? Should that act be amended? Because otherwise, in terms of the other schedules, Schedule 2, Schedule 3, the accounting officer is the boards are the accounting officer. And that's what the difference is. So I personally think it's a little bit of I think it's correct that the CEO is the accounting officer, not the members. I think Parliament was correct, but maybe I'm wrong. But then that some way of accommodating this in the PFMA should be found. The one was to list the information regulator under Schedule 1, which doesn't make it a Chapter 9. It's for the purposes of the PFMA. But ultimately, the question is, should the CEO of the information regulator be the accounting officer? But as far as the main issue the issue, as I understand it, that we were tasked with was the terms and conditions of service, and that I'm confident will be resolved by the next meeting.
Yeah.
Thank you. Let's hear before Dean. Let's hear Honorable Janji. Honorable Janji.
No, Chair. Thank you, Chair. No, I was going to make a suggestion, Chair, so that we don't prolong this brainstorming. We're busy with the brainstorming now, and I don't know if the purpose of us convening this meeting was to get into the brainstorming that is happening. The Deputy Minister of Finance has, amongst other things, he has raised and has been clear in areas where he thinks there's no clarity of their role, but has given a determination about a task that is squarely on them to come back after a month. And I think we've accepted that. But listening to the DM of Justice, even if the Deputy Minister of Finance comes back after a month, with that brainstorming, we are back on square one, as you are saying. So nothing is going to happen. And my suggestion would be, if we take the month timeline, I think we should also be asking the Justice through the DM and the Minister themselves also in that month to do some of the tasks so that, as you are saying, we go beyond the diagnosis. What are the concrete suggestions and proposals? And in that process, it might even help that the two departments and ministries speak to each other and come to us with some kind of a coordinated approach to this, which we don't have now at this moment. And thirdly, ourselves as the committee, we will do our own kind of assessment and clarify our own issues, whether it's in a form of us getting a proper legal opinion and the kind of work that we need to do. We can do that. But this is not helping and in terms of where things are now. I think we've had both deputy ministers. I suggest that we, through your leadership, Chair, we concretize that should be the way forward that we take. Thank you.
No, thank you very much. I think you're correct, Honorable Janji. Your parting shots, DM Finance.
No, I think without repeating what Honorable Janji has said, I fully concur that the issues around the listing will require all of us to do our homework, issues around should the CEO be an accounting authority of the Information Regulator, and what are the implications for that insofar as the PFMA is concerned, because I think colleagues are right that the PFMA will say in the context of public entities, a board is the accounting authority, and it's up to the board to determine how they delegate authority to the CEO and other committees. So on this one, we do need to go back and apply our mind in this regard. And I will also suggest in that context, Chair, that you should also have a conversation with the Standing Committee on Finance in the context of this conversation on how we solve this issue around the listing in particular. The other issues around remuneration, the Justice Department, from my understanding, they are undertaking a benchmarking exercise which they will share with the National Treasury and agree on what is an appropriate remuneration in the context of the constraint we're facing from the point of view of the fiscus. But on these other issues, on the determination of the conditions of services, which require concurrence, which has no financial implications, or there are financial implications, but it can be sorted out by the minister concurring, we'll definitely come back within a month. But I really want to appreciate your guidance and leadership in this regard, and we'll definitely come back within a month to provide solutions on these issues. And we're also looking forward to your guidance on the issues around listing. Thank you, Chair.
Thank you very much, Deputy Minister. Masondo, Deputy Minister John Jeffrey.
Chair, no, I think I'm covered. Just to say that the salaries issue is something, my understanding is the purpose of this meeting was on the conditions of service. That was the main purpose. The listing has really been between the regulator and Treasury. And it wasn't covered in the Minister of Justice's letter to the Minister of Finance. So but that does need to be addressed, and I agree with the processes being followed. The purpose of this meeting was the conditions of service, which I think we have heard from the Deputy Minister of Finance that it would be addressed within a month. The issue of the remuneration was also something the regulator raised. That determination of the salaries was done before the regulator started and was done with the concurrence of the then Minister of Finance. So that was done. The issue is that they're wanting a higher level, and we will engage with Finance or with Treasury on that aspect. But I don't see that as a particularly urgent aspect because the determination was done. But hopefully we will then get a response in the next month on well, we look forward to then a response on trying to resolve the issue of the benefits. Thanks, Chair.
Thank you very much. We would be pleased if in our next meeting we have one presentation that will be from both justice and finance, because everything at the end of the day will come back to resources, money, which would also include finance. So we do not want to have a presentation by justice and a presentation by finance. We would want them to meet and give us a consolidated presentation. And I would ask Dr. Lutz on our side, Ms. Silkstone, to look at this issue as to what can be done on our side as Parliament, whether did Parliament make an error, and if that error, if there is an error, whether we would need legislative amendments, even if it's a committee legislation to deal with that. Let's look at all of those issues. The difference, because there is an accounting officer and an accounting authority, and an executive authority. Whether we really do understand those three functions and how they find expression in the Act. And I think I would suggest deputy ministers that in dealing with these things, I think in some of the meetings, because we will have to invite Dr. Lutz and the team, the parliamentary team, so that there is a work program that will be consolidated, what Parliament must do, what Justice must do, what National Treasury must do. It must be one a program of action that we will we will report to one another when we meet the next time. We will also have on our side to meet with the chairperson of the Standing Committee of finance to further explore these issues. But we will also be guided by the work that would have been done by Dr. Lutz, Ms. Silkstone and the team in fleshing out the technical issues. Is that summary acceptable to the meeting?
Agreed.
Yes.
Okay. To the deputy ministers, are you okay?
Yes, Chair.
Okay, thank you very much.
I'm good, thanks.
Thank you very much. We know that you are very busy people. I think we have reached a stage where we can release you to focus on other issues, and we will proceed with other matters of the committee. Thank you very much for gracing this meeting, deputy ministers and to your teams.
Thanks, Chair.
Thanks, Chair.
Thank you very much.
Thank you, Chair.
Thank you very much. Can we now attend to the next item? The next item will be a briefing by Dr. Lutz on Judge Motata.
Thank you, Chair. Good morning, Chair. Good morning, members. If I can just kindly request the right to share, please, Chair. If Vunani can please assist me. Thank you, Vunani. Chair, my presentation on this is going to be very brief. I think quite a detailed opinion was circulated to the members, so I don't want to repeat all the issues. I think what's crucial just to highlight is there was a question around Section 24 of the JSE Act and whether there is actually, with regard to Judge Motata, a finding before the committee for consideration in terms of that 24 referral. Because the JSC initially said it's just misconduct, it's not gross misconduct, and then the Freedom Under Law took the matter to the SEA, and there was a consequential SEA judgment that said, but the tribunal's recommendation of gross misconduct was actually correct. But then the order from the SEA was slightly ambiguous in that it said the matter was remitted to the JSE for further processing in terms of Section 24. So upon studying that order, we see that there could be some ambiguity in whether remittance then means that the JSE must retake the decision, or whether the SEA is in fact replaced the JSE decision. If one looks at the JSE's overall judgment, the reading is quite clear that this court saw this situation as an opportune moment where a court could in fact replace its finding for that of the body that is originally tasked with the finding, the JSE in this instance. So when the court said remitted in terms of 24, it also did so following a paragraph that said it's not remitting it for purposes of 20 sub 3, which is where the JSE in terms of the Act actually has the authority to make a finding of gross misconduct. So we went to go look at the interpretation rules, and the SEA and the Constitutional Court work under the rule that if an order reads with ambiguity, we must give a sensible reading to that order, and that sensible reading is then given with due regard to the judgment as a whole. And from what we saw as a judgment in the whole, as well as taking consideration of the letter from the JSE by the Chief Justice in referring this matter to the National Assembly, our office is of the opinion that the JSE finding of misconduct has in fact been replaced by the SEA with a ruling that it is gross misconduct. So procedurally, for the Judge Motata matter, we see the referral as being procedurally compliant. There is in fact a finding of gross misconduct before the National Assembly then for consideration. That technicality then out of the way, Chair, you asked us to just look again at what the committee should do and identify steps for such a Section 177 consideration. Just to highlight again, as per a previous presentation, that if one looks at 177 and the roles of the JSE and the National Assembly, neither is subordinate to the other. The roles are different but equal. So the finding obligation falls on the JSE, and that's a jurisdictional precondition for the National Assembly to take its resolution as required in 177. So in that instance, as previously explained, the National Assembly should not reconsider the merits. That was the task of the JSE, now supplemented in this Judge Motata instance by the SEA judgment. But the National Assembly is then called on to make a political decision. And our office has identified steps that can assist the committee in taking this political decision. We are recommending that the committee must formally note the finding of the JSE in this instance. Now the SEA is a legal fact. So there's a fact that there is a finding of gross misconduct. Then as a second step, this is completely discretionary for the committee. We don't see this as a must, it's a may. If the committee would like a procedural presentation from an official of the JSE, such can be requested. That person, however, will be bound to the process, as the committee cannot enter into a discussion as the merits. But that is an option that the committee can take to just further contextualize the political decision that it is being called on to recommend to the National Assembly. As a third step then, Chair, we consulted with senior counsel on this one. The committee must invite written representations from the affected judge on calling for any extenuating circumstances that the affected judge would like the committee to take into consideration. Perhaps to contextualize here, it's I want to draw a comparison between like when somebody has a finding, a criminal finding against them, during the sentencing, a person can bring other issues to the court for consideration for sentencing. So seeing as the committee's recommendation to the House is then the equivalent of a remedy recommendation, should this person be removed or not. That's where these issues come in. So counsel advised that the committee must invite written representation, giving that person the opportunity not to enter into a discussion on the merits, but to highlight any extenuating circumstances that the affected judge would like the committee to take into consideration in making the political decision whether removal is the option to be followed here or not. Then for a fourth step, Chair, because the committee must apply its mind, there must obviously be deliberations on the matter. And then fifth, the fifth step is the committee must report on its political decision. And then as a final step, the National Assembly must consider that recommendation and take a vote as per the resolution that's required in section 177 of the Constitution. Thank you, Chair. That's all I have to highlight at this stage. Thank you.
Thank you very much, Dr. Lutz. Any questions or comments, members? Honorable Horn.
Yes, thank you, Chair. I want to engage Dr. Lutz on the statement that the decision to be made by Parliament is a political decision. Because I have a slight difficulty with that specific statement. In as much as I agree with her that the role of Parliament and the JSC is different but equal, I can't foresee a situation where Parliament can act in a constitutionally valid manner if Parliament, for purely political considerations, in circumstances where the recommendation as it now stands by the JSC after the intervention of the Supreme Court of Appeal is impeachment, that Parliament purely for political reasons can resolve that impeachment is not to follow. I see Parliament's role as one of the three spheres of government in this specific circumstance as less of a political act and more of the more in the nature of firstly performing the type of checks and balances which is part and parcel of our constitutional architecture, and which is not can never be or should never be tainted by political considerations. And lastly, or to complete that argument, Chair, Parliament is ultimately, in essence, in deciding on the matter, also performing a public power assigned to it by the Constitution, and in that sense, the ordinary requirements around rationality would find application. And to then, therefore, merely for political reasons, come to a conclusion that it is politically not, let's say, either sound or strategic or the political motivation of members would indicate a decision against impeachment would, in my view, be a breach of the constitutional obligations of members of Parliament in the circumstances. So with the greatest of respect, I do not agree with Dr. Lutz in as far as the argument is that Parliament is in the circumstances to perform a political function or even something that can be linked to policy considerations, which of course is always very much within the sphere of political consideration. Having said that, Chair, my view is, of course, that in then performing this very important constitutional function, we must strongly consider then at least inviting arguments in mitigation. But then, of course, the one aspect that must come into play, and maybe Dr. Lutz can venture an opinion to assist the committee in this regard, is when you consider arguments in mitigation, there, of course, is always the very real possibility that there could be arguments in aggravation, and who do we then look to provide those if it is then a duty on Parliament to consider those specific factors before performing that constitutional function. Thank you.
Thank you, Honorable Horn. Honorable Mola.
Thank you very much, Chair. Chair, I think the guide says procedurally we need to note the report as a legal fact. Then it gives us two options that may or must be the work undertaken by the committee, which is to request for a written representations from the affected judge, and may be the JSC as well. Chairman, I would like to propose that we note the report as it is tabled before us. Then we further request for written representation from the affected judge, but as well we may request a written presentation, not necessarily a physical presentation from the JSC. Then the committee sits on a determined day and deliberate on the matter, having received those representations. I wanted to propose a way forward of that nature, Chair. Thank you very much.
Thank you, Honorable Mola. Honorable Bettenbach.
Thank you, Honorable Chairperson. I'm largely covered by both Honorable Mola and Honorable Horn. Just to emphasize then that in terms of Section 177, Parliament has a very limited role in the impeachment of judges. So we cannot reopen an inquiry into the guilt or otherwise. That process has been finalized. It was finalized by the JSC and subsequently by the judgment in the courts. So this has been finalized, and this process has already been through the courts, has been made very clear inter alia in the Schloppe matter that Parliament's role is very limited. And so I too want to take issue with the description of our work going forward in this matter as a political, as giving political guidance to the National Assembly, reaching a political conclusion. I think it's exceptionally dangerous to mix the two, and I think it was probably just a poor choice of words, but I would like to hear Ms. Lutz on that issue. Thank you.
Thank you very much. Honorable Janji.
No, Chair, I'll be brief to just support Honorable Breitenbach on our limited role on this issue as directed by our supreme law. We're not going to change that, but also to support Honorable Mola on the proposal that he's making. I think on the issue that has been asked for Ms. Lutz to respond to, and it's quite a difficult one because, I would imagine if Ms. Lutz would indicate to me and define a political role that we must play, because the National Assembly plays a political role. We were elected there as members. Because the other extreme is whether she would say, no, your role is just to rubber stamp what is there. And I would not agree. There's got to be an application of our minds on these issues. And by our own definition, whatever decision we're going to take as the National Assembly, it will be a political decision. And so I think there's a bit of an anticipation of when we get to that discussion, which should not really be occupying us at this point. And I'll hear what she says, but I will be very uncomfortable if she defines to me as an elected representative as to how I apply my mind to that particular issue. The framework and the guidance is suffice to me. Thank you, Chair.
Thank you, Honorable Janji. Honorable Maseko Chele.
No, thank you, Chair. I'm covered. The only question that I would like to know is that issue of him having to make a presentation in written form to us when the decision has been taken by the court about him. What would be the intention? And what is it that we are expecting to get from him if he had to do that, Chair? If possible, we take that route. Just a question.
Thank you, Honorable Chele. Dr. Lewis.
Thank you, Chair. Thank you, honourable members. Chair, I hope I made note of everything. Please guide me if I omit to respond to something.
Sorry.
Yes, Chair?
Sorry.
Yeah.
Honorable, is that a new hand or an old hand?
No, it's an old hand, Chair, sorry.
Okay, please. Please proceed, Dr. Lutz. Sorry for that.
Thank you, Chair. I think overall I can perhaps answer all of the questions with in a single answer, I hope. I would like to just say at no instance am I saying the committee must rubber stamp. I agree fully with Honourable Janki. That cannot be the case. The committee needs to apply its mind, and that goes to the rationality that Honourable Horn spoke of. Perhaps just to protect myself, the political decision statement isn't mine. It comes from a court decision. It was the High Court in Shortlisting versus JSC actually made the statement that, and I'm quoting, the JSC is vested with the power to make a decision based on the norms of judicial ethics. The National Assembly makes a political decision. So that comes straight from a court case looking at how we interpret Section 177. So I'm not in a position to say whether that's a poor choice of words by the court, but it is this is a court interpretation of 177. And I think how Honourable Janki expressed it as Parliament being a multi-party body of representatives of the people, that's where the political decision, I think, comes in. Because there are, it is not, Parliament is not a court of law. So there may be situations where from a political representation, public interest perspectives, other considerations may come into play. So with that then being said, rationality required doesn't in law require the best decision, legally speaking. It requires a considered decision. So if, and I'm purely speculating here, I'm not drawing any conclusions. If there is a circumstances in which a committee finds when deliberating that even though there is gross misconduct, they, for numerous reasons that may be put to them as extenuating circumstances, vote that it shouldn't be removal. That's a political decision. It's that that you're taking into consideration other aspects, because Parliament is not a court of law. Parliament is not the JSC. Parliament does not make merit findings here. It makes findings based on the interest of the constituencies that is represented through the political representatives in this realm. So rationality does not mean that we rubber stamp. Rationality does not mean that Parliament needs to blindly follow a certain decision. Rationality means that Parliament needs to have a considered decision. Nobody can predict what that considered decision should be, but it should be a considered decision. There should be debate, there should be deliberation. And as long as we can show that members of the committee and members of the National Assembly applied their minds and then voted in terms of the democratic principles that is set out for this political realm, I think Parliament will be performing its duties. If we rubber stamp, if we just say Parliament should just follow blindly, that I would actually say questions the rationality. So I hope I've assisted. I think Honourable Horn, you said with extenuating circumstances, why just the affecting judge? Because we're looking at here the person whose rights and interests stands to be directly affected. So it's this your natural justice principles of being heard if you are the one to suffer the consequences. I think as public representatives, that's where the politicians come in to represent the voice of the people from individual constituencies, the people who voted the individuals in to represent them. So you will basically be seen in this situation as the voice of any aggravating circumstances, if you so wish to, if that comes from a specific constituency. But here, if you look at Audi and if you look at natural justice, that's why it's crucial for compliance that we at least allow the affected person who stands to be removed to put extenuating circumstances to the committee. Chair, I hope I've responded adequately. I'll be guided by you. Thank you, Chair.
Thank you. I think the other side of Honorable Horn's question is that where we will look for the aggravation, arguments for the aggravation.
Apologies, Chair. Perhaps I didn't fully clarify myself. That's where I thought, just from politicians as the representatives of the people, if there is somebody that feels, I want to say the politicians are the spokespeople here for that. Also, but you must take into consideration that it's gone through a process. Our focus here is not when you allow Audi is on the person who stands to be directly affected. Yes, there can be other aggravating circumstances, but that's issues then in the political deliberations that members can highlight. But yeah, I'll perhaps I'm not understanding the question fully. I don't. Yeah, as I say, I'll be guided by you.
Okay. Honorable Horn, on that question, are you covered?
No, Chair, I think it's something we must consider a bit further. Unfortunately, once again, with respect, I'm not following Dr. Loots's argument that we are only to consider possible factors working in mitigation. If factors in mitigation is part of the let's say the responsibility of the National Assembly, and I'm not arguing that it isn't, then to my mind, for us once again to go about it rationally, there must also be a process where we are then to consider any factors that work in aggravation, whether those can be sourced from the JSC tribunal's finding. That's of course one possibility. One would think that the tribunal would extensively invite and consider it when it proposes a sanction. But once again, to my mind, if we are to open the door to invite arguments in mitigation, because it is a matter of public interest, to my mind, there should also be the possibility then of asking the public, and not only the implicated judge, what their views are around both factors working in mitigation and aggravation, for as long as we as Dr. Loots rightly indicate, are the people's representatives and performing our functions in that context. Thank you.
Maybe it's something we'll need to think about, but what I would suggest, Dr. Lutz, can you bring back the slides?
I will do so, Chair. Let me just get back to it. There we go. Which slide specifically would Chair want me to focus on?
On the steps.
Okay. We'll go.
Okay. Members, what I would suggest is that I think this is a beginning of a process that we have never had before. It will be for the first time since 1910 that a judge is impeached, that we adopt an approach, in fact, we adopt these steps as an approach that will assist us in arriving at a recommendation to the House. But what we might need to do is to also put timeframes into some of the steps. For instance, from now on, how much time do we give to the JSC official to come and make a presentation before us? And then from there, when we have received a presentation from the JSC, we now have to come to a situation where we invite a written representation on extenuating circumstances. And then we will deal with also the issue that Honorable Horn is raising. How much time do we give to the affected judge to do that? And if we were to agree with Honorable Horn, you can't have an open-ended process for public comments, for mitigation or aggravation. So we have a tight procedural framework, which will also give confidence to the nation that this is how much time they should expect when matters of this nature comes before Parliament. Because if we do not have those timeframes and procedures out there, I think we will have situations where we would treat Honorable Janji different from Honorable Horn. So this is what I thought that maybe we can maybe deliberate on. Is a presentation to say, let's just one, adopt the steps as outlined, maybe deal with the issue Honorable Horn has raised, and I would suggest that step 2, it should be the way we deal with the Magistrate Commission, that we don't just invite a written submission, that an official of the JSC must come before us and make a presentation. I think it will be much quicker than getting papers over a period that has gone more over a decade, that we will have an official making the presentation, because my understanding is that one of the issues or areas that is a constitutional responsibility of the House in this process is to ensure whether in each step of the way there was a procedural compliance by the JSC. So that official from the JSC will be focusing on that procedural presentation, and we must satisfy ourselves that the JSC has followed all the procedures before we present to the House. And then on step 3, that is where maybe we might need to have a discussion based on what Dr. Lot is suggesting on extenuating circumstances, and what Honorable Horn is also raising, that maybe we might want to make a decision there. So, because once we agree on these procedures, I mean, those are the procedures that will cover any impeachment procedure for judicial, for judges that comes before us, or that comes before the committee, even when we are not there. That is what I would suggest, members. Any, Honorable Chair?
No, I support what you are suggesting. And also, I want to withdraw from that one of him having to make a presentation, because we have to use the same method that we have used with the others. Thank you, Chair.
Thank you very much. Any other hand, Honorable Janji?
No, thank you, Chair. Thank you for your guidance. It does help just so that you channel us to a proper way forward. I want, based on what you have said, also to move that we adopt this proposed committee steps. Step one, for example, is a decision that we are taking today, because we are formally noting this as a legal effect. And I like your step 2 and step 3 emphasis, because that's the gist of the work that we must do. But I would suggest, Chair, that based on this, under your leadership as the Chair and perhaps Dr. Lewis, we could ask a further planning out of this process in terms of the times and so on, instead of getting into that now in the meeting. So now that we are adopting the steps and the process, we then ask, can this now be programmatized to give the times and everything else? And then we follow that. It means our program has got to take that into account, because that directly affects, therefore, our program. And also, as we do that, especially around step, and I like the step 2, because we're doing that in terms of the magistrate. And let's follow that. Let's follow that procedure. It's tested by us. It does work. And I think under step 3, as part of the work that Dr. Lutzmas can still do, I still want us to differentiate between your extenuating and mitigating factors. They might not necessarily be the same kind of issues. So to also get help around that, because it's in step 4 that we're going to get, as we deliberate, having listened and having gone through all of those presentations in the program that we're going to outline. That I think we're going to do the kind of discussion that Honorable Horn was kind of anticipating, where we avoid being partisan. We become, because in step 2 and 3, we are oversighting every issues that is there. So, Chair, in effect, I'm supporting that to adopt this, but that having adopted that, let's now have an actual dated and programmatized, and I don't think that the meeting must do that. I think you can direct that with Dr. Lutz and the team and your Christine and the others to do that for us, and it can even be round robin and sent to us. I might not even need a meeting to come and do that, having adopted the major framework. Thank you, Chair.
Thank you very much, Honorable Janti. Honorable Horn.
Yeah, thank you, Chair, and thank you, as the Honourable Jayanti has said, also for your guidance in this regard. Chair, there's one other aspect I think that must be raised at this point, even though it's a, let's say, an additional issue. You referred to the fact that, of course, in adopting a protocol, it is important because that would be the roadmap for all how we would deal with all impeachments, and I think that's a very important aspect. So at this point, I must again raise the following issue, Chair, and that is, of course, the fact that we have been tasked as a parliament to deal with another impeachment prior to this one, which we have not processed yet, and that is the one of Judge President Hlophe. Now, if I was then, for example, to assist Judge Motata to argue around this, I would strongly raise the issue of not all judges being treated equally. So my very, very serious suggestion, Chair, is that we cannot keep on parking the Hlophe matter while we proceed to finalize the Motata matter. I am aware that in the programming committee last week, there was a presentation which, for some or other strange reason, seemingly indicated that to process the Hlophe matter will be a long and dragged out process. I think our roadmap in principle, as agreed upon just now, would indicate differently. But for us to expose not only this committee, but also Parliament at large, or not to expose Parliament at large to an argument that we are not giving effect to the equality principle, I must strongly urge that we now immediately also program the Globe matter to deal with in the same manner. Thank you.
Thank you, Honorable Horn. I thought that what we will do, we will to agree on these processes outside of the names of people. We agree on this. This is the process of impeaching any judge. Once you have agreed on that, then you come back to the program of Parliament. When do we process this one? When do we process this one? But I think in that case of EFF versus the Speaker, there was the issue that the Section 89 process, there was the issue that immediately you develop rules with a person in mind, those rules might not be fair. So I just thought that let's focus on just having the framework. Once we agree with the framework, then the next item, when we've done this one, we've packed it, then we say, these are the processes in front of us. This is how we process them.
Can I come in, Chair?
Honorable Chanchi.
Yes, I fully support what you say, Chair. We will take the issues Honorable Horn has raised, even as we do that. But I fully support your approach that we have to be clinical in how we do it. And so that there is never even any loophole of us being accused of being irrational and unfair. At the end, we're likely to take all those matters, but we must be on the safe side on the process and procedures in the manner that we do it. So I fully support your directive.
No, thank you very much. Because we will go to that discussion immediately after we have adopted this guidelines. So do we agree with Honorable Janji that we would just put the timeframes on 2 and 3, and then that also the issue of aggravation and mitigating, also when we do the committee deliberations, I mean, we would have received a presentation from the JSC, would have gone through the documents, would have looked
Chair,
Oh, am I the only one who's here?
am I the only one? I was also wanted to ask that.
No, I
Chair,
think we're okay. I think you're on mute or something.
I'm sure Chair has just disappeared. Yes, it's just disappeared. I think, but Chair was on the platform on closing the matter, eh? Am I right?
Yes, can somebody phone him or go
Let
and
him
look
come
for
back.
him in this house?
Kubudile, you phone him.
I will do that. Thank you.
Okay, can we just give him at least a minute, if not few seconds, just to do
we can
that?
give him 2 minutes. It's fine.
Okay, yeah, we can go take a break. Take a break of 2 minutes. Thank you.
Yeah, the chair is trying to connect back, so the 2 minutes will help. Thank you.
Sorry, members, about that. I was disconnected.
Yes, Chair, we are still on our 2 minutes break. You can just give
okay.
us, it's 1 minute left now.
Okay, sure.
Thank you.
Thank you, ma'am. Thank you.
Come back, Chair. Chair, you can come back and take over now. What time? Yes, thank you
very much. Thank you very much, member. I think I was kicked out by Honorable Horn.
Yes, and let that be a warning to everybody, anybody who just disagrees with me slightly.
What?
No, I will ask. Ask Honorable Breitenbach to protect me against you. So, members, with that summary, is there anyone who disagrees with the summary?
I'll take away his broomstick, Chair, and then he won't be able to do anything.
Thank you. We support the summary, Chair. Thank you.
I take it that. No, thank you very much. Thank you very much. I think we will work with Dr. Lutz on the timeframes, and then we will circulate that to members. Then the second sub-item on this issue is that we have two referrals. Judge Hlophe was referred some time back, and then we had to pause because of the programming committee's decision. I understand that the programming committee said we can proceed with that one. And then we have the Judge Motata. I think based on the program that we have just, in fact, on the guidelines that we have just adopted, I propose that we will formally write to the JSC to invite a briefing on the two judges, which would be step 2, because we must have step.
Chair, try to look for a better space. You keep on disappearing.
Step 1
Chair,
for Judge
Chair,
Hlophe.
Chair, I don't know if
Hello?
maybe it was me. You disappeared.
Oh.
Yes, just to sit properly, like, yes. Now we can see even your face. Thank you.
Oh, okay. So I was saying that since we have adopted these guidelines, and we know that there was a referral on Judge Hlophe and there was a referral on Judge Motata, we have done step 1 for Judge Motata, which is to formally note the findings as legal facts. I think we need to do the same for Judge Hlophe, and then we will write to the JSC for both Judge Motata and Judge Hlophe. But it will appear on the program as to when we are expecting a briefing on Judge Motata and when are we expecting a briefing on Judge Hlophe. It will be reflected on the program that will be circulated, and everything else will follow likewise. So we'll be processing these two requests this term, more or less we're going to issue in fact, we're going to do the first and the second step concurrently, and both steps would lead us to the other steps to be taken. Is there a problem with that approach?
No, Chair.
That's in order, Chair.
That's in order. Are you covered, Honorable Horn?
I agree on his behalf. Agree.
Yes, no, thank you, Chair. That one removal has clearly had positive consequences.
I must have the broom next to me. I think we are done with that, with the impeachment processes. We will meet with Dr. Woods to finalize the issues that we have advised that we need to finalize, so that and then we work out the program. The issue of the program, I have an update that is going to have a serious impact on the program. We will need to talk about that. Can we step off this matter? And thank you very much, Dr. Lutz, for the presentation, and the research unit for the research document that they wrote. I think it makes things much easier to understand where this matter comes from, and we would ask them to do the same for the shorter matter. Thank you very much. Let's go to the third item, which is the South African Human Rights Commission. I think, members, I misled myself here. I said today we are going to be dealing with the issue of shortlisting, but there's a step that we jumped, which is an important step. We have not advertised the candidates and their CVs for public comment, which is a very important step that needs to be done before we shortlist. So it will be important that that is done before we shortlist. But maybe we can have a discussion on that, and maybe we can take the presentation on the criteria that will be used to shortlist. Is that fine, members?
Yes, Chair, that is fine. I think the issue of public comments is a procedural matter. I think it's very important. I think it's very important. So I think we agree, Chair. Thank you.
Thank you very much. Any contrary view? None. So can we invite Ms. to the presentation of the criteria? And after that, we should agree on the time frame we will adopt for public comments. How much time do we give for public comments?
Yeah, are you ready for me to go ahead?
Yes, please.
Okay. Yeah. Can everybody see my presentation? Let me just try and...
Yes, we can see it.
Yeah, that's a bit better. Okay, I'm going to skip through a lot of the presentation because the committee is quite familiar with this, but just quickly to recap, we are, because it's been a while since we've actually dealt with the matter, there are 6 positions that we are filling, 4 in a full-time capacity and 2 in a part-time capacity. Yes. And then
just to also look at, and this is important because several of the commissioners qualified to reapply. Okay, so any person whose term of office as a commissioner has expired may be appointed for one additional term. And the other important point here is around the chairperson, that we need to make a recommendation to the House around the appointment of the chairperson. And then just going to the criteria for appointment, the formal criteria are set out in the Constitution and in the South African Human Rights Commission. Okay. Then looking at the Section 193 of the Constitution, it's the stuff that you're familiar with. Commissions must be South African citizens. They must be fit and proper to hold the particular office, and they need to comply with any other requirement prescribed by national legislation. In this case, it's the Act. The other important thing is that Section 193(2) of the Constitution provides that a commission established by Chapter 9 must reflect broadly the race and gender composition of South Africa. Then skipping to the legislative requirements, the first two are the constitutional requirements of being a South African citizen and fit and proper, but then there are two new requirements. The person who's appointed must have a record of commitment to the promotion of respect for human rights and a culture of human rights, and be a person with applicable knowledge or experience of matters connected to the objects of the commission. Also, another factor that we would need to take into account is that the Act highlights that commissioners must serve impartially and independently. Sorry, I see the chair. Oh, okay. The following persons are not eligible for appointment. Anyone who is appointed by or is in service to the state and receives remuneration for that service, an unrehabilitated insolvent, anyone declared of an unsigned anyone who, after the section took effect, was convicted of an offence and sentenced to more than 12 months imprisonment without the option of a fine, either in or outside South Africa, if that conduct would have been an offence in South Africa. Anyone who is an office bearer or staff member of a political party, member of the National Assembly, a permanent delegate of the National Council of Provinces, a member of a provincial legislature, a member of a municipal council, or who is on a candidate list for any of those positions. And then this is what sort of unpacking some of these essentials, and this is what the chairperson asked me to speak to. So if we start unpacking the issues of fit and proper and having the necessary experience and knowledge and so on, start going into criteria. Well, it's things like it can be put into four components, like character. So is the person independent and impartial? Do they have integrity and honesty? Is the person beyond reproach? Are they courageous and dignified? Do they have conviction of purpose? And do they have an open and inquiring mind? And of course, there are other character components, but these are some of the ones that we highlighted, that I'm highlighting. Then in terms of skills, we're looking at leadership and management skills, communication and language proficiency skills, and dispute resolution skills, and then investigative and analytical skills. In terms of knowledge, are they appropriately qualified? Are they competent with the capacity to give expression to the values of the Constitution? Are they an experienced person, including about the values and needs of the community and our society at large? And then looking at background and experience, and I like the term human rights champion. So we're looking at, do they have the relevant experience and training? Does the person have a proven track record of commitment to the values of the Constitution? And then I remember that we received a letter, the committee received a letter in 2020 from the chairperson of the commission around suggesting criteria for the appointment of commissioners. And I thought this might be helpful in terms of looking at the kind of, it's a sort of almost like a job description in some ways. So the commissioners are expected, among others, to provide executive and strategic direction and leadership, specifically in respect of all priority complaints relating to their focus areas. They're expected to ensure efficient and appropriate budget expenditure for their office/focus area. They are expected to engage with stakeholders. They're also expected to contribute to the process of educating the public on human rights. They form part of the delegations, but they're also expected to represent the Commission at national, regional, and international levels, relating to their focus area, or otherwise mandated by the Commission. They preside over hearings of priority complaints or appeals relating, especially to their focus areas, or such other area as the Commission may decide. They consider, approve, and take steps to enforce the implementation of investigative hearings, of investigations, hearings, and other reports, especially those relating to their focus areas. They execute the powers and functions outlined in the media protocol as well. And then the letter also spoke to the deputy chairperson's responsibility, which was appropriate at that time. But if we look at that, it gives you insight into what might be appropriate for the chairperson as well. So the responsibilities they have both programmatic and management/administrative responsibilities. In terms of their programmatic responsibilities, a chairperson would be expected to play, with the support and assistance of the Secretariat and other commissioners, a leadership role in implementing the Commission's mandate. This presupposes the ability of the ideal candidate to plan and strategize on how to implement the Commission's mandate, to monitor and evaluate progress and success, and to report and design adjustment plans. And then in terms of the management-related responsibilities, the candidates are required to play the leader's role, being responsible for coordinating the work of the commissioners on a broad strategic level to ensure that the Commission's key strategic goals are met. It also includes organizing and presiding over all statutory meetings of commissioners. The candidate would engage with the person would engage with the day-to-day activities of the CEO and consult and interact with the CEO on work-related issues. They would also undertake performance management of the CEO in consultation with other commissioners. They act as the executive authority of the South African Commission. They approve travel, leave, and other requisitions of commissioners. They oversee the financial expenditure of the office of the chairperson, mediate concerns and disputes raised over the exercise of the powers and functions of the chairperson, regularly consult, engage and interact with the chairperson regarding matters relating to the Commission. Oh, sorry, I think that's relating to the deputy chairperson. Exercise powers and perform functions as outlined in the media protocol. And then just the final, final thing is, and this is, I put this together, is around unpacking the essentials. These are the kind of questions that pop into my mind, would be when I think about that criteria. Is the candidate a person of integrity? Does the candidate have the necessary passion and motivation for the position? Is the candidate someone who displays a deep understanding of the observance of human rights in our society? Is that experience supported by a record of commitment to the realization of a human rights culture in our society? Is the candidate knowledgeable or have expertise in the field of human rights and have the necessary skill set for the position? What message would be given to our society at large if the candidate is appointed? And then just looking at the way forward, our outstanding issues are to call for, we need to call for public comment, and that's our public participation process. Agree on criteria when evaluating candidates, which is what we're considering today. The number of candidates to be shortlisted, how will the candidates for shortlisting be chosen? That's the process. The distribution of a questionnaire and screening process to follow prior to the interview. Thank you. Thank you. I'm done. I'm done.
Okay, thank you very much, Ms. Silkstone. Are there any questions or comments? Are we clear with the criteria as read out by Ms. Silkstone?
Yes, thanks, Chair.
Thank you very much, Honorable Breitenbach. Any objection to the adoption of this criteria? No objection. Thank you very much. Committee Secretary, the process of advertising, when should we expect it to start, and how long should it be on the...
Chair, we should be ready to upload all the CVs this coming Friday. And then, given that we are dealing with around about, I think we're dealing with 102 CVs, because out of the 104, one, Mr. Wang Jones has withdrawn. Two, there's a candidate with also a South African citizen. I think she is from Lesotho. So we've got 104 somewhere there. So I would propose maybe a week or two should be fine.
Be definite with your proposal.
It's a difficult one for me, but previously when we had a large number of CVs, there was a request for 2 weeks. So maybe to be safe, I would propose 2 weeks.
There is a proposal for 2 weeks, starting from Friday. Is there any objection to that?
I think it's enough, Chair.
Thank you very much.
Support that as well.
Thank you very much. Thank you very much. That is now taken care of. The next item, which I think is now relevant, I received a communication from the committee secretary that the House Chair have declined the study tour because of financial constraints and the fact that we have a lot of legislative program bills that we need to pass. Am I correct, Onan?
Yes, you are correct, Chair.
Yes.
That's
So,
fine, Chair.
Honorable Breitenbach?
That's fine, Chair. It's no problem.
Okay. So that is the position. It has been declined. Now, are there any other comments? None?
Yeah, Chair, no,
Chair.
Okay.
Honorable Janji?
Ek sien Werner Hon is baie vinnig voor my. Gaan maar aan, Werner.
Ag, vreeslik dankie man. Laat ek nou maar my kans vat as ek voor jou kan wees. Yeah. No, Chair, I mean the financial considerations is of course understandable, and I think we must be sensitive to it. Although, of course, the request was within the context of some other committees having had multiple study tours already, and that's being the first request. And the one other aspect I just believe one must take up, I agree with the Honourable Breitenbach that we must accept the decision, but the one problematic aspect would be that if the workload of committees is a relevant factor to deciding on who qualifies to embark on study tours and who not, it would ironically mean that the committees like ourselves with a very heavy workload would always be at the in a situation where we would not be able to benefit from the exposure, whilst ironically those with a lesser workload would then be in a position to benefit from that exposure, and that of course seems nonsensical. But I am in agreement that it would not be prudent for us at this stage to pursue the matter further. Thank you.
Thank you very much, Honourable Janji.
No, Chair. I think Honourable Horn has covered me because I think Honourable Breitenbach is correct. If the decline is based on there being no funding, we don't want to get into an unfunded trip. We've never wanted to do that in the first place. And I think if that is the issue, then that must be confined to that. Even if that's the issue, this committee has never traveled and taken any other of those kind of things. We're in the same parliament, we're in the same National Assembly, and we're in different committees, as Honourable Horn is saying, that travel, in fact, people travel almost fortnightly or every week. So, but we have to accept that if it's proven to be that, but there must not be a new criteria created for us, Chair. In fact, that criteria would even have been wrong, because if the date was the 30th of September to 7th of October, we had planned our program with that in mind. It can't come differently to say you, in fact, we don't agree with your program, because we've planned that program. That program was approved also by the very same chair of chairs. So that reason really doesn't hold water, and it shouldn't be even placed on us, because it's something else, and it's something that I don't want us to just leave it like that. We've got to take up the issue, not just for ourselves, but for the nature of this committee that is so seized with issues of legislation, the committee that meets 3 days a week than any other committee. It means we have been regarded as a domestically focused committee by default in terms of such criteria. That criteria can't be accepted. I think a better explanation needs to be given. If it is finance, we leave it there. But I would say, Chairperson, for now, we accept your report. If there's any other issue arising, we shouldn't really close off that important assignment. It remains an important assignment if you look at the issues that we wanted to attend. Yesterday, we had presentation about issues of whistleblower. That's an exposure that we want to go and see in other countries and many other issues. Thank you, Chair.
Thank you very much, Honourable Janji, and other people who spoke on this matter. I would propose that, given the fact that we would not be traveling, maybe we should use the constituency break to do some of the work, even if it's for few hours. For instance, dealing with the public hearings, and some of the issues, that's to offload some pressure on the program that is going to be starting with the BRRRs. We have made undertakings, for instance, with the Law Society, that we will be dealing with the issue that they've raised with the Master's Office. We have not done that. But we also know that during this time, I know Honorable Janji would be also with the Magistrates Commission. On the 2nd of October, we will be with the Judicial Services Commission, myself and Honorable Breitenbach. Maybe we can take some of the less contentious issues, and the remaining members just process those things, because we also have we are one committee that has the largest numbers of entities, and our BRRR processes is really meant for committees that have got one or two entities, and we are treated like all other committees that have got few entities. So that process becomes a pressure cooker on its own. We are required to finish 4 bills before December. In fact, before December, and to allow the NCOP to process those bills. So it is going to be, we have this Human Rights Commission interviews, depending on the number that we agree on to shortlist. Quite clearly, it will be more than 2 days to interview maybe 18 or 20 people. Because one of the issues we must also try and manage is to make people stay in the waiting room for a long period of time. That has got an impact on their performance, because when you are there, there is anxiety that should be taken into account. So our program should also take all of those issues. We have just adopted the issues of Judge Motata and Judge Hlophe. So it's a program that is going to be very, very tight. So I was suggesting that maybe we can use some of the days to deal with less contentious issues, so that we can free up the program to deal with the other issues when we come back. Can we have some comments?
That's fine, Chair.
Thank you very much, Honorable Breitenbach. Ms. Sixton, your hand was up.
I just wanted to, just to bear in mind that we only get many of the annual reports on this towards the end of September, so that first week of October is a lot of its preparation for BRRR. So, if the kind of background work needs of the researchers and support staff can be also taken into account when the program is developed.
Yeah, it's a valid one. It's a valid one. No, can we take this thing outside of the meeting, and because it's a valid point. They have 24 hours like all of us in a day. We do not have enough research and secretarial support. So maybe the chair and the research unit and secretarial support, we will just need to meet and consider all of those things, and pace the program in such a way that everybody can be able to cope. and still deliver a good product. Will that be fine, members?
Yes, Chair.
Thank you very much. Yes, I think we have dealt with the issue of the program. The minutes. Bonani, the minutes. Wavule. Ms. Ramano, Mr. Ramano.
Is he still here or he's gone?
I'm sorry, Chair. I see that Bonani is no longer with us.
Not answering. She's not answering. Sia, can you check Sia?
The telephone number you called is not available at the moment. Please try again later.
Can I suggest that we defer the minutes to the next available date?
Yeah.
Yeah, Chair, as it is, I've always understood that up-to-date minutes is a requirement to travel. Since we're not traveling, I think we can leave the minutes forever.
Yeah, maybe we should have a different request to attend Rabbi.
For me personally, that can also work too.
Yeah, because those who attend rugby, there is budget. So yes, let's defer the minutes. Just one issue that I have received a WhatsApp letter, in fact, a letter on a WhatsApp, and during the meeting today, I received also a call from the Minister of Transport. Quite clearly, what we received yesterday as a briefing that they have not signed a letter to the president about the president issuing a proclamation on the SIU is incorrect. From the letter, I mean, although I did not have enough time to go through it point by point, but is that they have done that to the president, supporting the work of the SIU, and that the president must appoint, in fact, must issue a proclamation. So it would be important that we give an opportunity when we come back to the Ministry of Justice and SIU to explain what could have resulted in the miscommunication. Is that in order?
Andre.
Thank you very much. I think we have come to the end of the meeting. Thank you very much, members. So we'll communicate a program, a fourth term program. We will also communicate the criteria with the timeframes as agreed in the meeting. And then we will look at when is the next available date for us to sit. Thank you very much. The meeting is adjourned.
Thank you, Chair.
Yeah.
Recording stopped.